Let's head to the courts. Justice James Omotosho of a federal high court in Abuja on Monday dismissed the fundamental human rights suit filed by the detained leader of the indigenous people of Biafra, Nnamdi Kanu, against the federal government. Kanu in the suit is seeking 1 billion naira in damages from the Attorney General of the Federation and the Department of State Services for alleged rights violation. Kanu claimed that the DSS and its Director General violated his right to a fair hearing by allegedly preventing his lawyers from having unhindered interactions with him where he is being detained in preparation for his defense in his criminal trial. Omotosho, while delivering a judgment on the suit, held that Kanu failed to provide credible evidence to sustain his claims. Let's discuss this with the help of legal practitioner and public affairs analyst Towo Oseruwoja. Towo, thank you very much for joining us.
Thank you, Felicity.
All right. The judge has said that Kanu failed to provide credible evidence to sustain his claims to a breach of his fundamental, right to fair hearing. What has been the conversation in the legal circles about the credibility of this case before now?
Well, can you hear me?
Yes, I can.
Well, anybody who is sincere to what is happening in our security or law enforcement agency, their environment, will know that the allegation by Nnamdi Kanu is not far from the truth. Because as a practicing lawyer and someone who had experience and who had carried out a lot of fundamental right cases, you know that these are issues that occur in the law enforcement agencies domain. Even though the law made it clear, if you look at the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 36, which talks about the right to fair hearing, stipulates the grounds upon which the role lawyers play or the role a suspect, though is no longer a suspect, is a defendant in the matter, but is also entitled to the constitutional rights. The constitutional stipulates in the Constitution. And if you also look at Section 6 of the Administration of Criminal Justice Act, which is binding in these proceedings, they also stated conditions in which a suspect, or in this case now is a defendant, can make a statement or interact with his legal practitioner, with his lawyer, which is the legal practitioner. But these are things that are going and are of concern. If you look at the allegation contained in that process, it's something that should be worrisome to the Nigeria Justice Reform Commission, the Nigeria Bar Association, and also the Human Rights Commission, because these are things that are happening and nobody can deny it. Even suspects, relative to suspects, lawyers or defendants who are kept in security agencies. These are things that you can't find in developed countries. But they're happening in Nigeria. I will tell you for a fact that, do you know that when a lawyer goes to see a suspect or someone in custody, they put him in a state of incommunicado? So you ask the question, why deprive the lawyer of his phone? Why deprive people of their gadgets when you know if the process is new and genuine? But take it or leave it. The court is like a place where it's what you bring before them, they adjudicate in. If there is no evidence, it becomes a mere speculation. So until these are looked into, evidence to a point, because facts can only be fact until it's admitted to become evidence in court. And the court does not deal on speculation. It deals on evidence that has already been admitted.
I want to jump on your concern. I want to jump on your concern with the courts. There are those who say the case against Kanu has been dragging on and is eliciting comments that the court is being used as a tool by politicians to keep a hold on the man. Is a political solution a better pursuit for Kanu's team at this time? What are his chances, and are the concerns about the courts valid?
Well, first of all, let me answer the first leg of your question. If the court has been used as a tool or for holding Nnamdi Kanu, the court usually in these circumstances become the victim. Because if you look at the administration, the justice reform process of Nnamdi Kanu, you discover that it is even when the trial is on, the investigation is ongoing. So most times, when you see all these cases that are reported in the Nigerian court, Sometimes the courts are fed up because it is in the course of the trial, you discover that even the law enforcement agencies are sorting out evidence or bringing evidence or amending processes because they've not concluded investigation. Like let me give a good example now. In UK, you discover that it takes longer process for investigation, shorter process in the court hearing. But Nigeria is not so. The investigation is so short, then the judicial process becomes longer because, in the course of it, you see, they try to junk so many things together. So that is for that. Then for the political settlement of it, you see, there's something I want to draw Nigeria's attention to. It's not everything you look at it politically, because when you sort it politically, the aftermath becomes so devastating. Look at what happened in the Niger Delta. After the Niger Delta Commission that was set up as a result of the unrest of the youth or the self-acclaimed freedom fighters, can you tell me the tangible development that has brought? It made individuals billionaires are even more powerful than the government. So there are certain things that the government need to follow the due process of the law, so that anybody who knows such intention knows the consequences surrounding their actions. Because we cannot say political settlement, whereby we give criminals or political criminal elements leverages to trample or traumatize Nigerians in the course of fighting either their self-acclaimed freedom, their self-acclaimed political ideas and other stuff. So that is just it. Then the last aspect of it is that the justice reform system needs to be looked into. It needs to be looked into, because one thing is that why people are craving for political solution is because of the faulty justice reform system, particularly at the point of investigation. The law enforcement agencies has a lot to do in this regard.
All right, so we'll have to leave it there. Thank you very much for speaking with us.
You're welcome.